Hi, it's Anne-Marie from Charmed Life Therapy again. I had a busy night overnight again last night, so I'm going to try and make a shorter video because I don't want to do big humongous videos that make you watch for forever, but there's so much going on right now, it's quite hard to keep it short and talk about kind of my perspective on it at the same time. So obviously one of the main things that's happening is that it's been revealed that Isabella Ferrer has now, well, they've been trying to get hold of her, put a subpoena on her since 3rd of July. So that's quite a long time now. We're in the middle of August. And Isabella Ferrer's been quite a fascinating person, really, because obviously there's been many people have said that she is like a member of the Clooney Ferrer extended family, if you like, but if you try and track that down, it's really hard to find specifics of who she is and who is her parents. It does say that she's of Puerto Rican and Irish descendants, so the Ferrer family is Puerto Rican, but if you try to actually get a hang of it or Google it, or I've been down a rabbit hole again, I did it a while ago and I was trying to figure out who she was because it's a relatively unusual surname in the movie industry, I guess. Couldn't get any specifics then, and I can't really now, but people are assuming she is part of that family. I haven't seen anything proved, but I guess if she is, then she may be fairly well protected because it's a relatively powerful family, isn't it? And I noticed, but there's basically nothing on her IMDb page. But it does mention that she often, somewhere that she spends a lot of time with her mother in Ireland. So I think they might be having to look for her in Ireland, I would guess, if that's, because it's a fair distance away. If she's felt the need to go and hide away somewhere, that very well may be where she is. So it's a bit in the air as to whether she is actually a member of the Ferrer family, because if you do try researching, you'll come up with the more normal spelling of Isabella with 2 L's and things, because there is an Isabella in the Ferrer family that has 2 L's. But trying to track down, given the ages of the various members of the Ferrer family, where she might likely tie in is quite difficult. So it's not just as straightforward as Googling her. But if any of you out there have specifics, I'd be interested to know, because to me she's been quite a figure of mystery. And I kind of find it hard. I hope she's all right, for starters. I truly hope she's okay, because I'm sure this is being very difficult for her. And again, like Justin, I guess it raises a lot of questions for you as a person, when likewise she started off having a very good opinion of Justin and then was swayed a different direction. And I imagine there's always been a question in her mind as to what was real and what was not real, and did Blake Lively truly like her, or was she groomed for a purpose? You know what I mean? I'm sure there's been a lot of that going on, and I'm sure she's probably had to seek professional help for some or all of this, and it has tanked her career in the interim while all of this is going on. So it's had no small impact on the girl, so you got to feel sorry for her. But I kind of don't really understand the point of trying to duck out of being subpoenaed. If this was me, and you've got to remember that everybody is motivated differently, but some people are motivated towards moving towards the problem, so like tackling it head on, getting it out of the way, and the rest of it, eyes on the prize and the rest of it. And some people are motivated by avoiding what they don't want to encounter, and both ways work. The avoidance way, where you do things so that you don't get a negative impact happen as a result of doing that, or you're the other kind that just moves toward, always is looking to move towards something, like meeting it like a bull head on or whatever. And both strategies work. But when it comes to this, if I was her, I would want to get this over with. I wouldn't want it hanging over me any longer. So I guess the question in people's minds is, what threats are hanging over this girl? What influence has Blake had? Is her career being dangled over her head? Has she been, because like we've got a situation now where even the person that is supposed to be her solicitor, Wayfarer can't get a response from the solicitor. So it's rather difficult. But yeah, It's like you got to admire Perez when he knew that Lively was chasing him with a subpoena. I mean, he had a tiny bit of fun with it in the beginning, but then basically said, look, here I am. I can tell you, I've heard you looking for me. I'm right here. Come and get me. He did that kind of thing. If I were this girl, I'd just want to get on with it and get it done. So you've got to ask the question, what else is going on behind the scenes that we don't know about? And it's fairly straightforward what she's being asked for. Not like poor Catherine Case and Brianna Koslow, who are having an incredibly difficult time. And there's a nice letter I'm going to get to in a minute from their counsel. So Isabella Ferrer, what she's been asked for, these RFPs. Number 1 is all documents relating to any discriminatory, harassing, retaliatory, inappropriate or unwelcome action, conduct or statement made during the production, editing or promotion of the film. Straightforward enough. 2, all documents relating to any complaint, grievance or report, whether formal or informal, oral or written, of harassment, discrimination, retaliation, workplace misconduct or any other inappropriate conduct or statements made to any person during the production, editing or promotion of the film. Again, very straightforward, not complicated. Those kinds of things would stick in your mind for sure if you came across them or heard them from a third party or whatever. Request for production number 3, all documents relating to any intimate scenes in the film, because obviously Baldoni has been accused of saying inappropriate things. He's been accused of putting like a sex scene in there that needn't have been in there according to the book, supposedly. And also for making an inappropriate comment when the film was done, something along the lines of, that looked really good, I know I'm not supposed to say this, but have you been practicing? Which he may or may not have said, and without seeing his face and his tone of voice, it's very hard to know how that was delivered. But that's what we're being asked for here. What was, in terms of a document, what was being expected of her, what was her perspective on it? What was she expecting, basically, to have to do? Request for production number 4, all communications between you and Lively relating to A, the film, B, any Wayfarer defendant, or C, the action. Okay, straightforward again. Request for production number 5, all documents produced in connection with any subpoena in the action. Request for production number 6, all communications relating to Baldoni. Number 7, all communications relating to Heath. And that's it. That's literally what she's being asked for. It does beg the question, did Blake Lively ask her to delete text messages? When I pulled that face, then I thought, oh God, that feels like a Perez Hilton expression that I just pulled with my mouth. I'm watching too much of this stuff, quite clearly. It's bad enough when you do things that you know is like an expression of your father's. Bless him, never mind Perez Hilton's. No offence to Perez, I don't want to start mimicking his facial gestures. But yeah, that's the first thing that pops into my head. Was she that much under Blake's sway that she's actually done something she maybe shouldn't have done? Whether she's had any pressure or not, and that will come to light if she has to answer this subpoena. But to me it's fairly straightforward, and I have to address the fact as well as people are pointing out that we've had an awful lot on the docket about doxing and all of that, and people objecting to it, and Perez's children on the internet and stuff like that, which the judge still not has addressed the fact there's actual pictures of his children on the docket, which seems wholly unnecessary. You can allude to it without needing to put their pictures on there. That seems very not okay to me. But I'm not a lawyer. I don't know the ins and outs of it. But in this subpoena to Isabella, there are 2 addresses listed where they've attempted service, and it's like, it kind of is quite shocking to a layperson, isn't it? That seemingly it's okay to just wang your addresses out there for all and sundry to know there's a good chance maybe of catching you there at some time or place. It seems really strange to a non-legal person that it's just not standard practice to redact people's addresses and phone numbers and banking information and things like that, but it seems to be the case. So yeah, as Perez pointed out, if he's going to have to bash Lively's side for it, we equally have to bash Baldoni's side for doing it too. But maybe that's just the practice. Maybe we're all reading too much into this stuff. So yeah, so there's been I believe 5 attempts to serve Isabella Ferrer since early July. So she's aware of it in some sense. What's really funny is that it highlights how suspicious people tend to be, because it's like wherever one of these guys has gone, it's like they didn't want to give the real name. You know, they're called John Doe, Jane Doe. Everyone is talked to in relation to, is this person here? And nobody claims to know her. And it's like, I don't know, is it that different in America? It's like me here. It's like practically the whole village knows who I am and I basically know nobody. But it's like, you know what I mean? It gets around kind of. You would have thought somebody would have heard the name or been aware there was an actress living in the building, especially somebody who's been in quite a famous movie at this point. But everybody's claiming no knowledge of her. Now, she might have been a bit of a fly-by-night and it were just like a bolt hole, these places, and she was just coming and going and living with family at other times. We don't know, but she is aware that people are chasing her, so why not just confront it head on, unless things have happened that you would rather have not happened, and you've done some things that may have been not a great idea in hindsight. So other than that, we've got Leanne Newton, who's done another really, really good letter, but I'm not going to read it all, but it's basically just reiterating that there's a lot of letters on this docket where people are saying Blake Lively does not just get to withdraw these subpoenas as moot. She's caused damage here and she's withdrawn them as moot so that she gets away with not addressing the fact that people want some form of sanctions and some form of monetary relief for the harassment that they've been put through. She didn't prove there was a valid reason for subpoenaing all these people and causing them expense and loss of time and all the rest of it. So Leanne Newton has reiterated in a new letter that she's requesting relief from the court. She wants a protective order barring a reissue of any subpoena for her data on any platform to anonymous or non-party individuals without court leave. So basically Blake has to go. She wants an order in place for herself, but it would apply to anyone, I guess, because if one gets it, then it opens up the avenue for everybody else to ask for it. But Blake Lively should be going to court at this point if she's issuing any more subpoenas. There has to be a reason to do it. Award punitive damages as a sanction for abuse of process and grant any other relief the court deems just and proper. Because it's gone into all the reasons, such as all of that, you know, the times that Ezra Hudson and co claimed that there were meet and confers that took place and all of that, and most of those, as far as we know, did not take place. A few emails were exchanged back and forwards, but questions were often just not answered. There was no explanations given, no clarifications given. So it left people feeling really insecure and really at risk. So it's right that people keep saying, actually, because there's loads of stuff now at this point on that docket, largely because Blake has been dumping so much on there that we're way behind on actual orders. And there's stuff here that's going by, including some of Perez's, that are either not reaching the docket or are not having an order being made upon them. So, you know, it's time Judge Lyman was getting his ass kicked, basically. So he has now put an order on Judge Lyman. And I believe this is relating back to Katie Case and Brianna Koslow about not redacting information and stuff. So he's basically put, on August 8th, Counsel for Blake Lively filed letter motions to compel and an accompanying declaration in support of the motions, docket 587. Exhibits D, E and H to the declaration included personally identifying information, PII, in the form of personal phone numbers. Pursuant to its supervisory powers, the court ordered docket number 587 administratively sealed. There's case law quoted which states that district courts have supervisory power over their own records and files, and that supervisory power is routinely used to redact or otherwise restrict access to sensitive personally identifying information contained in court documents. The court determines under blah 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 that the higher value of protecting the individual's privacy rights in their personal phone numbers overcomes any presumption of public access to that information, as the PII has no apparent relevance to any pending motion or legal issue, and the redaction of the information would be narrowly tailored to promote the individual's privacy interests. Going forward, the parties, so everybody, will not be required to seek the court's permission to redact in public filings PII in the form of personal phone numbers or email addresses. So it doesn't actually state physical addresses, unless those numbers or email addresses have some plausible relevance to a pending legal issue. Accordingly, Lively is directed to publicly refile a version of docket number 587 with all phone numbers and email addresses redacted from the documents. So it's clear as mud, basically, isn't it? And Perez was complaining that Baldoni, mildly complaining, that Baldoni's subpoena had gone out there with addresses on, but that may well have crossed this order in terms of what's gone on the docket, because everything is going on out of order at this point. But it's kind of strange that the physical address is less important than the phone number and the email address. So, but I don't understand the law or the logics of that. So let's move to a rather nice letter from Prior Cashman, LLP, on behalf of Katie Case and Brianna Coslow. And this is Maxwell Breed partner, and he seems very on it and very good. So dear Judge Lyman, non-parties Catherine Case and Brianna Butler Coslow respectfully oppose the letter motions to compel the production of privileged materials filed by Ms. Lively, dockets 585, 586. Ms. Lively, a public figure of substantial means, demands privileged attorney-client and work product communications, hoping to come up with evidence of a non-existent and ultimately non-actionable smear campaign that Ms. Lively claims without support Ms. Case and Coslow are shielding under claims of privilege. Counsel for Ms. Lively should be aware, even from our non-party productions, that our clients were not involved in any smear campaign and that the few materials withheld are privileged. Ms. Lively's counsel did not meet and confer with us on many items raised in their papers. Had they, their false assumptions would have been corrected. To that end, we will be providing an expanded privilege log in coming days, as this docket needs no more vitriol or hyperbole. We respectfully correct the factual record below. You've got to love some of this lawyering. They do get in some good digs. I know I'm totally biased at this point, but I do feel like the Wayfarer side and is it Jackson Walker for Jed Walker for no Jackson somebody that's for Jed. I'm getting Jed's last name's gone out of my head now. Is he Jed Walker? It's gone. Anyway, he's really good. And these guys are really good. There's like a humour to them, I think, that you don't seem to get from the Ezrals. Now, whether that's just the bias in me, but they seem like a bunch of stuffed shirts on Lively's side, and these guys seem like they've got a bit of humour. And it's like even when things aren't going well for them, it's like they still find a way to kind of bring a bit of levity to it that illustrates they're not quite giving up just yet, you know, and hang on in there. So the background: heeding this court's June 24th order, we coordinated with Ms. Lively's team to collect materials responsive to her document subpoenas. We established search terms, trained a review team, and reviewed. Despite the delay in Ms. Lively's deposition, and in brackets, the professed basis for expedited review, we made the vast majority of our production on July 16, 2025. Ms. Lively's counsel then identified potentially privileged communications and inquired whether their production had been intentional. We investigated, clawed back certain materials, and I think that's legal language, this idea of clawed back. It's not like a desperate thing, it's just the term it's given. and reproduced on July 19th, 2025. Although hundreds in inverted comma of records were clawed back, that figure is knowingly misleading as it includes artifacts embedded in text chains. So then it, in quotations, it's like fewer than 75 text conversations, each a 24-hour period of messages containing a hit on a search term were clawed back. After the clawback, and I'll just pause there because there's a footnote, the Wayfarer parties seek to review communications with overlapping claims of privilege. We will therefore confer with them regarding their claims of privilege as we finalise our revised privilege log, which we've heard from Wayfarer already. Having used the same vendor as Ms Lively when we met and conferred on this issue, Ms Lively's counsel represented that they understood this fact and that there were not, in fact, hundreds of documents clawed back. So that's all in the footnote. So going back to the letter, after the clawback, we met and conferred with counsel once on July 18th about privilege. We explained the inadvertent production, provided grounds for asserting privilege, justified use of a categorical log, and discussed a single participant in a single withheld communication. There's often this idea of it's just one person that's knocking around in a lot of these communications that is maybe a content creator, possibly Perez, but as if it's just this one name that may or may not be responsible for the entire untraceable smear campaign, this pivotal person that keeps falling under attorney-client privilege, much to Blake Lively's ire, probably. I don't know, but we know there's nothing to this, really. So I'll carry on with the letter, but I know there was something popped up yesterday, wasn't there, that Blake would like to think was proof of a smear campaign. But anyway, so we also discussed the waiver doctrine and shared our positions that, one, the common interest exception to waiver applied, given that the employees, TAG, and Mr. Baldoni shared a common legal interest in defending themselves, including from Ms Lively's unfounded claims about a smear campaign against her. And two, the communications were protected by overlapping claims of privilege as both individual employees and the employer entity received legal guidance. Ms Lively's counsel never stated, either then or after, that any privilege assertion was contested. So their argument. Ms Lively misstates the law on privilege. Ms Lively suggests that privilege cannot attach to the challenged communications because they occurred before the retention of certain attorneys. This ignores well-established precedent, holding that parties may seek and receive legal advice in anticipation of litigation before formal retention, and that such communications are privileged if made in furtherance of legal advice, and there's a case law linked there. Regardless, as will be made clear through our revised privilege log, no communications with outside counsel occurred before retention, apart from two communications between Ms Case and her father. The first withheld communications are from December 21st, 2024. Ms Lively I can't even, we've got a running total of words I can't pronounce now. Movement. Now we've got misstates because it's misstates. So when I see that, Ms Lively misstates the law on waiver. Ms Lively contends that privilege was waived by the inclusion of TAG employees and third parties, such as Jed Wallace, but privilege is not waived by the presence of 1. Individuals who share a common legal interest in the advice rendered, or 2. Individuals whose involvement is reasonably necessary to obtain or act upon legal advice, and more case law stated. They've been kind enough to supply links, and the upshot of that citation is no waiver when communications are engaged in a common legal enterprise with the holder of the privilege. So TAG, its employees and others involved in the PR representation of the Wayfarer parties were entitled to coordinate with counsel and to pursue a unified legal strategy. Of course they were. It's common sense, isn't it, to be talking to each other Crisis PR professionals routinely coordinate with legal counsel on both PR and legal matters. None of the individuals listed by Ms. Lively were outsiders, all were instead integral to the common legal strategy. No waiver of attorney-client privilege was affected as a result. Ms. Lively relies on Hoff versus Schroeder to suggest that communications with PR professionals are not privileged. But her reliance is misplaced because the communications in question were not mere transmittals of information as a part of a PR campaign, but related to a common legal interest. In brackets there it says, because there's something quoted, noting that there was no legal character to the communications in question. Then it goes on. The parties to the challenged communications, particularly in the wake of Ms. Lively's action, shared a common legal interest, vindicating themselves and prevailing in this suit. That's a fairly good common legal interest, isn't it? And again, C. Schaeffler 806, noting that a common legal interest existed because the parties to the communications had a strong common interest in the outcome of the legal encounter. And the letter goes on. I don't know what Etienne is doing upstairs, but she's driving me mad. The cases cited by Ms. Lively do not involve situations where agents were sued along with their clients and are therefore inapposite. So then there's a little footnote. Following Ms. Lively's inquiry, we re-reviewed the one communication at issue. Upon further review and additional factual inquiry, we determined that although the communication involved counsel and opened with attorney-client privileged, in all caps, common interest privilege did not apply, and we produced that communication. And there's bound to be the odd one or two things that slip through the net when you're talking about using search terms, and you know what, you know yourself, when you do a search on anything, you get whenever I try to search this docket and I'm quite specific, I get a ton of things that are nothing to do with it, you know what I mean? So then the letter continues, inclusion of former employees does not work a waiver. That's how it's worded. It's not a mistake in how I'm reading it. I don't know if that's correct, or inclusion of former employees does not work a waiver. Ms. Lively's assertion that privilege was waived when Ms. Case left TAG is incorrect. Courts recognise that communications with former employees remain privileged if made to assist counsel in gathering facts or formulating legal strategy related to the former employee's work. So then there's more case law quoted, and in brackets that means virtually all courts hold that communications between company counsel and former company employees are privileged if they concern information obtained during the course of employment. More case law cited. The content and purpose of the communications, not employment status, governs privilege. And correcting a prior mistaken understanding on our part, Ms. Case's last day at TAG was January 24, 2025. So work product doctrine squarely applies. Plaintiff dismisses the applicability of the work product doctrine by characterising the challenged communications as mere PR strategy. She's very dismissive, isn't she, Blake, of other people's PR and what they're doing. It's quite funny, really. But work product protection extends to all materials prepared in anticipation of litigation by or for a party, or case law stated. The withheld materials, which include drafts of the counterclaims filed in this action, fall squarely within this protection. Communications between Ms. Case and her father are privileged. Plaintiff demands production of messages between Ms. Case and her father, a litigator at Dykema Gossip PLLC, suggesting that such communications could only be privileged if Ms. Case were a party to litigation or was concerned about potential liability. But the communications involve Ms. Case receiving legal advice from her father and retained counsel, having retained his firm as of August 28, 2024, seeking guidance on how best to conduct herself was an exercise in prudence, and any insinuation to the contrary is scurrilous. In-camera review is not warranted. This is what Blake wanted in-camera review. In-camera review is reserved for situations involving credible basis to question privilege claims predicated on non-privileged evidence. Case law cited. Ms. Lively offers no evidence in support of in-camera review, only speculation and rhetoric. Absent specific and substantiated evidence of improper withholding, in-camera review should be denied. Ms. Lively's motion is improper. Ms. Lively's motion imposes additional burden, freaking well does, they've been through a lot, these two ladies, on two non-parties who are not celebrities, public figures or high net worth individuals. Evidently, Ms. Lively hopes that she will find in Ms. Case and Koslow's privileged communications what she did not find in their productions. Based on our review of the materials produced, the productions demonstrated that there was no malign, covert effort to smear Ms. Lively. The many produced messages show that the PR plan was reactive, not proactive, and that bots were never used. The communications show that negative content posted by content creators was organic, driven by Ms. Lively's own actions, like her wardrobe choices and liquor promotion. I've not seen that before because I only gave it a quick skim this morning. As perhaps exacerbated by her counsel's aggressiveness, negative internet perception has been public discourse about a public figure, not the product of a conspiracy. So, conclusion. The motions to compel should be denied. The communications at issue are privileged and no waiver of that privilege was effected. Ms. Lively's request for in-camera review is unsupported and should be denied. We thank the court for its patience and consideration. So that's Maxwell Breed. And I've liked some of his letters before. He seems to be really on it. I thought that was a really good letter. I thought it was even better after I got to that last part. But yeah, that's kind of where I'm caught up to for the day. I know there's still plenty of things outstanding and things that are available free to me at this point because I'm not paying for this stuff off the court docket. I'm not going that far into it, that far down a rabbit hole. But yeah, I think we're getting to the nitty-gritty now, aren't we? Because Blake's running out of options of where she can source information at this point. We're heading towards the end of deposition. I know Wayfair have asked for an extension of time, I believe, for another couple of days for something that's completely gone out of the top of my head, but I know there's something pending there. But I think we're getting to the next major milestone in it all. And I don't think it looks good on Isabella Ferrer that she's clearly making pains to avoid being subpoenaed. Be interesting to see what happens there. But you let me know if you found definitive evidence that she is part of the Ferrer family, the extended family. Because if she is, she may be very well protected in this instance. But if she isn't, then she's just like this young actress that's been a party to this thing that she never asked to be a party to, under pressures that most ordinary people would never have to be exposed to, and in this hellish place between somebody that you believed treated you well on the movie set, that you had no issue with, that to all intents and purposes seemed a stand-up guy to you in your personal estimation, and then you're exposed to this very wealthy, very compelling, beautiful woman who dressed you and draped you in jewels and had you stay over at home and baked you muffins and cookies and probably all the rest of it and showed you a different side of life, and spun a very compelling alternate narrative that made you question yourself and what you should and shouldn't do potentially either. So poor Isabella Ferrer may be in this awful position whereby she's been influenced to possibly delete some things or get rid of some things or say some things that she wishes she hadn't said in hindsight, that now potentially might be forced to be part of a public record because of all this. So in many ways, I think you have to have an awful lot of sympathy for there's a reason this entire cast is silent. Young Atlas, young Lily, Jenny Slate, all of the rest of them, there's reasons they're silent, you know what I mean? They had enough at the time. I think, as we said in the last video, by the time they were promoting it, I think most of them had clearly had enough of the Blake Lively roadshow, and were probably glad to be out of it. But yeah, that's my feelings on what I've caught up to so far today without going on too long, hopefully. Please do hit that like and subscribe and share, and really appreciate all of you being here and following my perspective on the journey. I really, really, really do appreciate that, and I will see you later.